I'm Mark Alexander. I think I'm most valuable as a relatively objective counselor for my client, and I think that the court appreciates that. I know that there's the advocacy aspect of it, which, fine, we can advocate positions for the client capably, but as far as the remaining objective, I think that's invaluable because the client and the other party are going to be emotional. They are intimately involved in the conflict, whereas I'm most useful in explaining what's important in the eyes of a judge and what isn't important. So acting as something of a buffer between the parties is a primary function that I serve, in addition to counseling my client how to deal with difficult situations. If I have to go to court, I don't jump up and down. I don't yell or shout or interrupt the other side. I think that's counterproductive. I think that in the eyes of a judge, they would rather see a relatively unbiased presentation based on the facts, supported by evidence, rather than making unsupported allegation. I feel that first I've got to educate the client as to what is important and what the court expects. So they need to understand that they may not like to disclose to the other party the separate bank account, but they need to. The court's going to expect it. The court rules require it, and any judge is going to feel that the parties both have a fiduciary obligation to disclose everything to the other party. You can't make an informed decision without being informed. So once you make full disclosure to the other side, they have a feeling that we're dealing in good faith with them. And that's what I expect from them as well. And when you're dealing in good faith with another party, you can usually reach common ground. Slinging mud is probably counterproductive. I think that the explanation that, for example, Washington is a no-fault state makes a lot of the emotions that fuel the conflict irrelevant. It doesn't really matter to the judge why the parties are getting a divorce. What the court has to decide is divide the assets and debts, deal with children, parenting plan and child support, maybe deal with spousal maintenance, and any restraining orders in an appropriate case. That's it. I think the court understands that it's probably not black and white. The court would appreciate a more balanced presentation, recognizing the positives, but bringing up and documenting, supporting the negatives. And that's the kind of a presentation that I think the court would much rather see. It's the overstating cases that the court probably gets very tired of, and to see a relatively objective and respectful approach to the opposing party and opposing counsel has got to be a breath of fresh air. I like to work with opposing counsel on getting proposed final orders and then going back and forth and say, how would you change that? And at the end, we have agreed orders that are ready for the judge to sign.